What happened?
I was in the house, and the officers got told to come in, and I was, like, I was running my mouth to them, disturbingly, and they was like, "What's going on?" And I refused to get arrested. So
Okay.
they had to put
When you were doing all of that, at some point, it became loud enough to to
yes,
disturb the peace and repose of the area surrounding you?
yes,
And you could hear it outside at some point?
yes, because I end up going outside
And you were yelling.
Janae Cummings.
Your Honor, our client would like to enter a plea. You should have the paperwork.
Judge, that is probably my fault.
I'm sure it is.
No, really, it was Deputy White's fault, Your Honor. When I tried to go.
You're just talking to stall for time. What are you doing?
But yes. Ms. Cummings, could you sign this, please?
Hmm.
They didn't, I tried, right? I didn't sign it. It's in this, discuss.
Yes,
Okay. You're disturbing the peace, okay?
today.
And you were pleading guilty. You gotta tell the court what you did. But not yet. He's gonna ask you. Sign this one right here.
Really?
I'm sorry, Judge. So I no think so, Miss,
Got to blame the day.
because he was like, Stephanie, no. And I was like, right there. I was like, and there you have it. All set, Your Honor. Thank you.
I finally have before me a plea form that indicates that the defendant was pleading guilty to the added count 2 of disturbing the peace, the 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct.
That is correct.
May I have her sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name, please.
Janae Cummings. Could I say what happened?
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Okay,
You understand that?
yes,
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
yes,
You understand that?
yeah.
Okay. You paused. Do you have an issue with that, or
What court is that?
what court is that? It's part of my court, but Judge Barr is the presiding judge there. It's a court in Ypsilanti.
Okay,
Okay, you understand that?
okay, okay,
All right. Understanding all of that, do you still wish to plead guilty
yes,
to that charge? How do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Do you have any question regarding any of those rights?
No.
All right, on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plead?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you are indeed guilty?
yes,
March 5th, 2026, at the location of 420 Emmett Street, City of Ypsilanti, Washtenaw County, State of Michigan. Were you out in public at that time?
no.
All right, what happened?
I was in the house, and the officers got told to come in, and I was, like, I was running my mouth to them, disturbingly, and they was like, "What's going on?" And I refused to get arrested. So
Okay.
they had to put
When you were doing all of that, at some point, it became loud enough to
Yes,
disturb the peace and repose of the area surrounding you?
yes,
And you could hear it outside at some point?
yes, because I end up going outside and
And you were yelling?
yes,
Yeah, okay. All right. Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, misconduct is defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
yes,
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
Keep us satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1. That's the pre-sentence investigation and report is ordered at 14H probation. Sentencing will be April 15, 2026, 10 a.m. before Judge Fox. All right,
But if I could address bond.
why?
I already posted.
I
You
don't
already posted it?
Yeah,
Perfect.
say yes.
I'm sorry, Your Honor.
I just,
Didn't see it on the. Yeah. Did you get out on the other case?
Yeah.
Perfect. No, never mind, Your Honor. We good. Thank you.
thank you.
oh, I guess bond, bye. Bond will continue.
Thank you, Your Honor.
I wish you could say, Miss Glenn, don't let her come back up. The court calls the case, People versus Eric Mayfield.
Andrew Childress, praying on behalf of the people.
I'm so sorry. Joy Gaines, Senior Assistant Public Media. Everything.
Your name, sir?
Eric Mayfield.
Thank you.
Mayfield?
You're seeking media discover.
Your Honor, we are seeking adjournment in order to get more discovery. Thank you for calling this case in the earlier timeline.
Yes, I see. April 23rd, 2026, 9 a.m. or as your invite indicates. Continue. Thank you. Court calls case, People versus Larry Kasserer.
No, welcome to the people.
All right, well, we have Costa, Your Honor. Morning. Morning. State your name, please.
Larry Kasserer.
Your Honor, I was advised by Mr. Chavalowski that there may be an additional charge coming against Mr. Kasaru. He was looking into reaching out to the OIC to further information about that, but as far as I'm aware, there's nothing additional.
Correct. As my knowledge, we have not received an updated information.
So anyways, we're asking for an adjournment to try to get that issue ironed out.
Probable cause conference, April 16th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir.
Have a good day.
The same. Court calls the case, People versus Ahmad Issa.
Your Honor, Joe Simon on behalf of Mr. And state your name, Ahmed Issa.
Thank you.
Your Honor, first things first, I don't know if the court has entered my substitution of counsel. Thank you.
Yes.
And given that, because I just substituted in, I'm requesting an adjournment of the.
That's the only reason.
Your Honor, I'd actually request the quickest turnaround because the people got me discovery today. So I'll be ready.
What do you want? 1 week, 2 weeks?
I'm here in 2 weeks. I know that, and I could do 1 week. That'd be fine.
Well, I can do 2 weeks. You haven't gone through discovery with your client though.
That's true. We literally just got it.
April 16th, 2020. Right?
How tall are you, Teresa?
6'6".
Oh, just.
And I wasn't going to say anything.
Thank you, Your Honor.
Every time I'm seeing you, I imagine you flew. And thank you, Bond.
Thank you.
Court calls the case, People versus Thomas Kumasaka.
In control of the hearing on behalf of the people.
Public Defender Natalie Pate, on behalf of Mr. Kumasaka, who is approaching. Please state your name for the record, sir.
Thomas Kumasaka.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
He's pleading, this form indicates that he will be pleading guilty to the count 2 charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
May I have him sworn?
Right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Thomas Kumasaka.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Stand that.
Yes.
You wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Question regarding those rights?
No, Your Honor.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I understand.
You understand you're giving up your right to appeal, all right?
I understand.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
July 1st, 2023, at the location of 2455 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you in possession of cocaine?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Sir, if between the time that I accept your plea and the time of sentencing, if you commit conduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court?
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14:1. Probation sentencing will be April 29, 2026, noon, before me.
Your Honor, may I briefly address bond?
Right.
Thank you, Your Honor. Mr. Kumasaka is asking if the court consider setting his bond at a personal recognizance bond. He states to me that he's not on probation or parole. I believe this is the only current pending case in Washtenaw County. I will acknowledge he does have a Wayne County case where he's scheduled for sentencing on April 6th. He does understand that even if out of custody, he would need to contact probation to complete his pre-sentence investigation report and return to court for sentencing on the 29th at noon. Given the age of this case, we're asking if the court would consider a personal cognizance bond.
Well, what else does he have pending? Because his bond was set at what, 25? Well, he was on a personal recognizance bond initially, and then didn't show up in August. How did he come back into custody?
I don't have that information in front of me, Your Honor, because I know he's been in for about 40 some days. Is that correct?
48.
And he's not being held on it, but there was a case that was already dismissed, I believe, that my client indicated, a paraphernalia case. But I don't know if that's how he came into custody or not, but that did occur since this.
Didn't turn himself in.
No, I do not believe so.
Did not turn himself in. Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Douglas Crockett.
And Assistant Public Defender Natalie Payton on behalf of Mr. Crockett, who should be present on Zoom. There he is. Sir, can you please state your name for the court?
Need to unmute, Mr. Crockett. Thank you.
Douglas Crockett. Good morning, Your Honor.
Good morning, sir.
Thank you, Your Honor. Thank you, Your Honor. Mr. Crockett, we do believe discovery is complete to our knowledge. He's asking that this case be set for preliminary examination.
Preliminary Will the people have their witnesses available the 14th? Preliminary examination will be set April 14th, 2026, 9 a.m. before Judge Moore. Bond will continue. That's an in-person procedure, so you'll need to come down to the courthouse.
I understand.
All right, thank you.
Thank you, Your Honor.
Oh, excuse me, Your Honor, out of curiosity, it's the 14-1A district court, correct?
Correct.
Okay, thank you for the information.
The best
Have a good
one. All right, take care.
Thanks, Mr.
you as
Crockett.
well.
Thank you, Your Honor.
All right, throw that out. Court does call the case, people versus Leonard Logan.
Your Honor.
Now, Michael Gaddy is the defender on the end of the movement.
Sir, what's your name?
Leonard Logan, sir.
Thank you. What are we,
We're asking for preliminary examination.
discovery is complete.
To the best of my knowledge, Judge.
Will have the witnesses available the 14th. Preliminary examination will be set April 14th, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Court calls the case of the people versus Wilnisha Crosby.
People.
Veronica Glenn on behalf of Ms. Crosby, who is not here because she is, oh, sorry. Oh, I'm sorry.
Go ahead.
What'd you do?
Can I talk? I don't know. I thought that you were supposed to say something and he was telling me I don't know. Made me nervous.
You made her nervous. Did you? Made her nervous? I don't know what that's all about. Starting to act like Cannon.
Oh no.
I know, right? Anyway. All right. Slim, go ahead.
Thanks. Your Honor, we would like to adjourn this matter because
Do you have a client?
no, I'm going to tell you why.
Okay.
She's not here because she is in the Wayne County Jail, and we have.
To lead with that.
I'm sorry. I will. Your Honor, my client is in the Wayne County Jail right now, and at this time, we would like to request an adjournment.
It,
And we already have proof submitted to the court.
you have what?
Proof
Proof of what?
of her being in the Wayne County Jail.
Did I question it? What? We will. All right. Do we know how long she's going to be there?
We have no idea.
All right. What I will do is I probably should issue a bench warrant, but what I'll do is I'll adjourn this out to the 23rd, 2026. 9 a.m. If she's there, maybe we can get her on Zoom and try to resolve this. All right. Thank you. Court does call the case People versus Jeffrey McCullough. What's up?
Assistant Public Defender Jay Ballinger on behalf of Mr. McCullough. And Your Honor, Mr. McCullough, can you please state your name for the record? Jeff McCullough, morning, Your Honor.
Good morning, sir.
Your Honor, I will state on the record that there are no offers at this time on this matter. As such, we are staying the course and asking to set for a preliminary examination. Discovery is complete to the best of my knowledge.
Of course.
I'm in.
Oh, so I said those funny little phrases. That's funny. All right. Stay the course. All right.
There's more from my client than anything, Your Honor.
No, I got you. So we'll set it. You have all the discovery though.
To the best of my knowledge, Your Honor.
All right. People have their witnesses available the 14th. All right. Preliminary examination will be set April 14th, 2026, 9 a.m. That is for Judge Moore.
Let's see what we can get rid of.
All
right.
Thank you.
Your Honor.
Court does call the case People versus Philip DePatricio. Patrizio.
It's not a threat. Asking, it's better Michigan work rule, 8.120.
Why do you guys make her stand all the way back there? Just no, you made her stay all the way back there and yell at me. Hold on one moment. Go ahead, young lady.
I'll start again.
Okay.
In court rule 8.120, under the supervision of assistant prosecuting attorney.
She did it perfectly. Ms. Enda's finally letting her do things. Permission to, yes, I called you out. Permission to practice if you're any.
Monica Glenn on behalf of Mr. DiPatrizio. There we go. Can you state your name for the record?
Philip DiPatrizio.
Okay. All right. Thank you.
Your Honor, we would like to request an adjournment in this matter in order to allow time to meet with our client. We haven't been able to reach him, but we have him here today and we'll have his contact information.
But you've gotten the contact information.
Not yet, but I will make sure that I have it.
Any objection, Councilman? This matter will be adjourned to April 23rd, 2026, 9 a.m. or as your invite indicates. All right. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Michael Moore. Yes.
Joy Gain, Senior Assistant Public Defender, representing Mr. Moore, who's approaching the podium, Your Honor. Mr. Moore, would you please state your name?
Michael Spencer Moore. All right. He's got 3 other cases that he's done and they're set for the 9th.
That's correct, Your Honor.
Need all of these together, right?
That is what we are requesting.
Oh.
Also like to address bond.
That makes sense. So that probable cause conference will be adjourned April 9th, 2026, 9 a.m. Get all these. All right. Yeah. Yes, that's about it.
Now, it's my understanding that Mr. Moore, for the 3 new cases, has a low cash bond and a release. We are requesting that he receive similar bonds so that he can be released and in this matter as well.
What I will do is I would sign an order that he can be released to treatment on a PR with a GPS tether. And I don't need to change his bond. I would sign that order. So that I think clear the way. All right.
Thank you.
So at this point, his bond will. If you get that order to me, I'll sign off.
Thank you.
All right. Court calls case, People versus Christopher Duffy.
And then on behalf of the people.
Wow, she let her do 1 case.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Duffy, Your Honor. He's
One case.
as am I.
She let her do 1 case. Only gave her 1 file.
Patroness.
Like she needs to let her get out there. You know, the people that had Zenda they let her do like the whole docket. No, and look at the fine attorney she's become. I don't know why she wants to hold other people back. I'm sorry for having this conversation and everybody's listening. Never mind. Go ahead.
Mr. Duffy? Christopher Duffy.
Your new approach.
Oh boy, here we go. Is it? Oh yeah, come along. Wow. So great. That was sworn out on Tuesday.
Like what the police agency is.
Which police agency?
What?
YPD.
Okay.
Wow,
Thank you.
that was dramatic. Court does call the cases of the people versus Tyler Watts. All three. Or two, I'm sorry.
This is for like defendant and I mean, Mr. Watts again, the 25FB1347 case.
And Sherilyn Foster Tucker on behalf of Mr. Watson, the case in 174.
And I have two plea forms in the case ending in 1734. There is the plea form indicating he's going to plead to count 3, use of methamphetamine, the 1-year offense. Counts 1 and 2 would be dismissed. And then in the other matter, the plea form indicates that he would be pleading to 3 charges. Count 2 of operating while intoxicated. That's the stated count 2. Count 3, which is a 93-day offense. Count 3, which is failure to stop at a property damage accident, which is a 90-day offense. And a count 4 of use of methamphetamine, a 1-year offense, which is an added count. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
For my case, that was correct, Your Honor.
And that is correct.
All right. May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Tyler Watts.
All right. Sir, it is this court's understanding that you're going to be pleading to 4 misdemeanor charges. Is that your understanding?
Yes, sir.
All right. In the case ending in 1347, you'll be pleading to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And also then in count 3, a failure to stop at a property damage accident. That's a misdemeanor punishable by up to 90 days, a $100 fine plus court costs. You understand that?
Sir.
And also count 4, which is use of methamphetamine. That's a misdemeanor punishable by up to 1 year, a $2,000 fine plus court costs. You understand that?
Yes, sir.
In the case ending in 1734, it's the court's understanding you're going to plead guilty to the charge of use of methamphetamine. That's a added count 3. That is, again, a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. Do you understand that?
Yes, sir.
I also have to apprise you that on the previous case, the 1347, while I'd be taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand all of that?
Yes, sir.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right. To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of failure to stop at a property damage accident, how do you plead?
Guilty.
To the charge of use of methamphetamine as contained in the case ending in 1347, how do you plead?
Guilty.
To the charge of use of methamphetamine as contained in the case ending in 1734, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
All right. Need you to look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am. Probation.
Were you on probation at the time of these offenses?
Yes, sir.
All right. You understand that your entry of pleas in these cases could be a violation of that probation.
Yes, sir.
You understand that if it is considered a violation of your probation, you could be sentenced to the maximum allowable under those other charge or charges. You understand that?
Yes, sir.
And understanding that, do you still wish to plead guilty to these charges?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of these offenses?
Sure.
Let's start with the case, the 14th, well, I'm sorry, You know, I told you you'd be sentenced before Judge Barr. You'd actually be sentenced before Judge Washington. You understand that?
Sure.
Still wish to plead?
Yes.
I don't know where I got Judge Barr. All right. On the date of March 7, 2025, at the location of West Michigan Avenue and East Manfield Street, Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested in some form methamphetamine?
Sure.
All right. Were you stopped by the police or was there an accident?
I believe in this case, I was stopped by the police.
All right. Were you do you know why they stopped you?
Yeah, it was after an accident. Sorry.
There was an accident? Recall what happened?
Honestly, no.
All right. There was an accident of some type and the police came to the scene. Do you recall that? All right. And when they came to the scene, were you ultimately arrested?
Sir.
All right. Were you taken to the hospital?
Yes, I was.
All right. Was there a blood draw?
Yes, sir.
Did the blood draw show either the presence of methamphetamines or its derivative?
Yes, sir.
Do you have any reason to dispute those test results?
Yes, sir.
All right. And on that same date, well, let me ask you this. Prior to operating that motor vehicle, you had used methamphetamine.
Yes, sir.
You knew what you were using was methamphetamine. Is that correct?
Yes, sir.
All right. And this might be a little bit harder. You don't remember the accident?
Honestly, no.
All right. Do you remember stopping at the scene of the accident?
Oh,
You remember driving away from the scene?
yeah.
May I have word, dear my client, briefly?
Okay.
So, Mr. Watts, do you remember when the officer approached your car? Because did you have interaction with the officer that day where he approached your car?
Yeah.
And you were coming to?
Yes.
And then when you woke up, you saw your vehicle and realized you had been involved in an accident?
Yes, correct.
And how did you realize you had been involved in an accident?
The front end of my vehicle and the officer told me as well.
Okay. But the place where the officer came into contact with you was not the place of the accident, right? Let's do this. Do you have a part of the police report that I don't want to stop it if we can get it done. Do you have a part of the police report that gives me, it seems to me that what happened, but he may not remember, is that his vehicle was involved in an accident. And then at some point he left that scene, didn't report it, but then ultimately came into contact with police officers.
Absolutely, Your Honor. I can read that police report, and yes, what happened, I think where he was hesitant to answer the scene, it was very nearby. So it wasn't technically the other vehicles involved, but yes, I can absolutely get Your Honor that police.
Well, I didn't need to know that. I just need to know he didn't immediately, he left. So I'm going to take a plea to count 2. He got involved in an accident, left that scene. I don't care necessarily how far.
Absolutely.
I just left that scene and didn't report that, but came into contact with police.
Correct.
Yes, sir.
I have it read in front of me, the report in front of me before it wants to look at it.
Yeah, but that's any objection?
Not at all. Thank you, Mr. Childers.
Got it. All right. So because you can't remember, sir, you have a problem pleading no contest to the charge of failure to stop at a property damage accident?
No problem.
All right. You understand that all of the rights that I explained apply to a guilty plea as well as a no contest plea?
Yes, sir.
All right. And I think the basis that's been stated on the record is failure to remember. And so formally, I'll just ask you, sir, to charge count 3 of failure to stop at a property damage accident, how do you plead?
No contest.
All right. And the court had reviewed the police report in that case. I think I got that. I'm going to move to the next case. We'll just find it. Ask you on the date of April 24th, 2025, at Michigan Avenue near Platte Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, sir.
On that date, had you used it? Did you know what you were using was methamphetamine?
Yes, sir.
Now, sir, I do have to advise you that, just correct my plea form here, that was good. You have to advise you that between the time of my acceptance of your plea and the time of your sentencing in either of these cases, if you commit misconduct as defined under the Michigan court rules, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand?
Yes, sir.
Is counsel aware of, in either case, of any other promises, threats, or other inducements which have led to a plea?
So, Your Honor.
No. No, Your Honor.
And have I, on both of these cases, complied with the court?
Yes, Your Honor. Yes, Your Honor.
In the case ending in 1347, court will accept the defendant's pleas of guilty to counts 2 and 4 and no contest to count 3. Count 1 is dismissed. In that case, the pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 30th at 10 a.m.
April 30th, 2026, 10 a.m. That's before Judge Washington. Bond on that case will continue. In the other matter, get my paperwork here, court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
April 29th at 12 noon.
April 29th, 2026 at noon before me. Bond will continue in that case. All right.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
We got through it. Okay. Court does call the case of the people versus Juan Edison.
Your Honor, Reagan to cook for the people.
Who? Ms. Gaines? Edison? No, it's okay. I'm sure Mr. Bellinger was tracking.
I think I was
No, it was. Oh, tired. Go ahead, Mr.
Joy Gaines, Senior Assistant Public Defender representing Mr. Tuan Edison. Your Honor, Mr. Edison Tuan Edison?
Yes.
Did call our office. He resides in Detroit. He is waiting for his ride. He asked for an adjournment. So we would ask, he asked that you pass it to the next. Well, I'm asking that you pass it to the next block, or in the alternative, may we please have an adjournment?
Did Bellinger tell you to do that?
No, he gave me other good advice.
For you, Ms. Gaines, I will pass it.
Right, thank you.
Sure, he's on his way.
He was still waiting for his ride when he called just a few moments ago. So his ride is supposed to be coming to pick him up.
Bellinger's not doing anything. Send Bellinger to pick him up.
Okay.
Okay. All right. I'll pass it to the next.
Okay. All right. Thank you.
Court calls the case People versus John Mulder.
We have people.
Brian Bowling on behalf of Mr. Mulder. You know. Can you just state your name for the record, please?
John Mulder. Thank you.
Your Honor, I'm asking for an adjournment. I'm still waiting for some video from the prosecutor's office with respect to the incident. And then I also submitted an investigator request through my office to hopefully get some additional video. So we could.
Pardon?
Another date if we could.
Yeah, not a problem. I would normally put it out to the 16th. And I need longer than that.
Probably.
Okay. Great. Well, is he being held on anything else?
Yes, he is.
Okay, gotcha.
Yes.
Probable cause conference, I'll adjourn that to then the 30th. April 30th, 2026, 9 a.m. Bond contingent.
I requested all that.
Okay.
Like we talked about yesterday. You're all set.
Okay.
All right.
Cool.
Court calls the case, People versus Dallas Fritz.
Presidents for the people, Your Honor.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Fritz, who appears via Zoom, Your Honor.
Hello, how you doing?
Okay. You have a camera, Mr. Fritz?
Yep.
Oh, there he is.
And candidly, Your Honor, it has been a minute since I've been able to speak with my client. As far as I'm concerned, based on our prior conversation, he is ready for the plea today, but I would ask Mr. Fritz to let me know if he has any further questions about this plea, because if he's more comfortable adjourning so I can have an opportunity to talk to him more about it, I'd be happy to do that.
Mr. Fritz?
Yeah, is it okay? Can we, are we able to adjourn it, Your Honor, one more time?
Yeah, that's fine. We'll just hold the forum. How much? A couple weeks?
I think a couple weeks would be more than sufficient.
All right. No, that's not a problem, Mr. Fritz. We'll adjourn it out so that you can make sure you know what you're doing, right?
And Mr. Fritz, my understanding is that your out date for treatment might be on or close to the 14th of April. Is that correct?
Correct.
Okay, so but you're in California, right?
Yeah.
So after your out date, are you coming back this way, or are you still gonna?
Yeah, I'm coming back home, so.
Okay, so let's do this then. If we're gonna adjourn it out, 14th. You think you'll be back here by the 23rd?
Yes, Your Honor, I will be back by the 23rd.
Oh, let's do it this way then. I'll adjourn this probable cause to April 23rd, 2026, 9 a.m.
Thank you very much, Your Honor. I appreciate that.
Bond, continue. All right, Mr. Fritz, take care.
Thank you, Your Honor. I have a quick question. Do I need to bring any paperwork that you need that proves I was in treatment or anything like that? Because I can get that stuff.
Okay, you should probably have that with you so you can give it to your attorney.
Okay.
Okay?
All right, thank you.
You're welcome. Court calls case People versus Michael Agbana.
For defending, Your Honor. Mr. Ogbana is approaching.
Your name, sir? Michael Agbana. Thank you. All right.
Your Honor, we're asking for an exam on this matter.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 4th. Preliminary examination in person will be set April 14th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Jason Haas.
Stephanie Pan on behalf of Mr. Haas. Mr. Haas, could you please state your name for the record?
Jason Haas.
Why are you up here?
I wanted to do something.
Why?
You're not taking that from me? Judge, please. Don't blame Mr. Haas. Oh, yeah, touch part. Your Honor, we're just asking for a permanent matter. There is a plea to be had. It was made this morning. My client is going to avail himself of the plea, but we just need to get the paperwork to the court.
Paperwork in.
Yes. Your Honor, when appropriate, I'd like to talk about bond in this case.
Probable cause copy. Sir, I'm going to adjourn your case out a couple weeks so they can get the paperwork to. Sir, I'm going to adjourn it out a couple weeks so they can get that information. April 16th, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Esteban.
Your Honor, Esteban, right now my client, in regards to this case, it started a while ago. He was convicted in Monroe County for count 1, which is how we got to our plea. But he was in jail for 6 months and did probation, and now he's here. Right now, he is the act
Charged it in another county.
Yes.
What is this count 1?
Yes.
Got it. Okay.
He pled to it, and so he had to do jail time. He had to do testing. He had to go through sober living. He did all the stuff associated with it. Right now, he is being asked to drug test and come back up here to do a lot of things that he's kind of completed already down in Monroe County. He understands that he'll be on probation here, but he's asking if we could at least make it so that he's either just doing the sober link or testing at community corrections. The financial cost of it is quite a strain on him because.
Well, I'm not following. So what is he currently doing you said Monroe, right?
Your Honor, because of the age of this, he completed what he needed to do for Monroe. He did everything that they asked. He was recently successfully discharged from Monroe.
I was sentenced to 300 days.
Yeah. And so.
Incarceration. Okay.
And so the only thing he's asking for on today's date, is that we could make testing less.
Could I do the random drug tests and not?
Hold on. She's doing okay. You don't need help her.
It's fine.
Response from the people. So. So currently, what is he doing testing wise?
He is has to do the sober link 3 times.
So my question is because there was what was his BAC on this case? Allegedly.
The drug intoxication on methamphetamine and fentanyl.
Right, but I'm looking at the complaint. It says a combination of alcohol. But if you're telling me there was no alcohol, then I'm not understanding why he's on a sober list.
It was just drugs.
That's correct. It was just drugs.
Okay, then the complaint says something I got. Okay, so what I'm gonna do is I will grant this and defendant the sober link testing is removed.
Thank you so much. Thank you so much, Your Honor. We appreciate that.
Thank you, Your Honor.
You're welcome. Do you have the device with you now or no?
Yes, I do. It's in the car.
Okay, so we should be able to get this over to him. You can return it so you don't get charged another day.
Okay.
All right.
So just go drop it off there.
Thank you.
Like an hour. Thank you so much, Your Honor.
We're gonna let him know you're on your way over there.
Yes.
Thank you, sir.
Court calls case People versus Hubert Price.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Donathy Leba for Mr. Price, who is approaching. Price, can you tell the court your name, sir?
Hubert Earl Price.
Thank you.
And Your Honor, I'd like to set the matter for preliminary examination as well as address bond, please.
Said all discoveries complete.
It is, Your Honor.
You will have the witnesses available the 14th.
For best, Your Honor.
Preliminary examination in person will be set April 14th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Your Honor, I did want to address bond if possible.
Go ahead.
Your Honor, Mr. Price has been in custody for, I believe, the past 26 days. He's attended every hearing in this matter aside from the 129 hearing that led to his incarceration when he missed it. What he's explained to me is he mistakenly believed it was on Zoom and that his sister, who generally provides him transportation, was told that she did not need to be available that day. He did explain to me that he's confident she's going to be able to take him to all hearings going forward, where he does have verified contact information with him, and he does have housing in Saginaw that he can return to. Additionally, I would note the case from 2021, and Mr. Price has not been in legal trouble since then.
We'll come back for Victor.
You said there's nothing else holding him?
There's nothing else holding him, Your Honor.
If you could pick up on this.
Any response from the people?
And just a quick second, there's nothing else in the next year. I apologize.
No, it's okay.
I'm having judges who are released to treatment here. I do have concerns given the nature of the allegations here, specifically the quantity, well as this prior which does have priors for possession of narcotics as well as an armed robbery, but that armed robbery did incredibly little, dating back to about 1972. But there's been a pretty consistent string of criminal history between that armed robbery in 1972 up to about when this occurred in 2021. I admit I don't see anything since 2021, but I have concerns given incredibly lengthy history.
Right, but he was on a PR. There were about 5 or 6 plus hearings. He appeared at all of those hearings. The end of January, he doesn't appear. So quite frankly, the court's major concern is not so much his criminal history, given the fact that he was on a PR, it's just his failure to appear on that day. And now this matter being set for preliminary examination, what I'm going to do in this case is I'm going to grant the modification for bond. I'll reset his bond with its conditions back to a personal recognizance, a $5,000 personal recognizance bond. I will indicate, however, that the defendant will need to be placed on the GPS tether prior to his.
Thank you, Your Honor.
And Your Honor, which judge was the exam? I got the date. It's not judge.
Judge Moore.
Thank
You're not
Yes, location tracking.
When they can do the test.
Thank you.
You're welcome. Court calls case People versus LeVon Jones.
No surprise, Your Honor.
Assistant Public Defender Don Felipe for Mr. Jones.
Your name? All right, what are we doing?
Your Honor, I've been requesting an adjournment in this matter. We're still discussing discovery.
Without objection, probable cause conference will be on April 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Landre Carey.
Good morning, Your Honor. Joy Gaines, a Senior Assistant Public Defender with and on behalf of Mr. Terry.
Your name? Little Andre Terry. They really named you Little Andre? Like that? That's funny. I mean, that's a great name. That's what I mean. Go ahead.
Your Honor, I believe you should have a green sheet from us. We are requesting
I do.
an adjournment so that we can receive some media that we are to receive some additional media and also to try to work out a global resolution for his other cases.
So he's got other matters.
That is correct.
All right. I don't mind granting the adjournment. Do we have any indication as to when these other things are set? Or
Yes, Your Honor.
I'm just looking at timing.
He has a retail fraud third in the 14A3 court that is scheduled for April 6th.
Okay. So you're looking to wrap back with this.
That he also has some pending matters in 15th that he was just on yesterday.
Okay.
that we also hope to work on. I do not have the new date for the ones in 15th yet.
What I'll do, I'll adjourn it out to the 16th, 2026, 9 a.m. And then hopefully we can wrap those up or do whatever you're going to do by that time. All right.
Thank you, Your Honor.
All right. Carrie, thank you. Court calls case People versus Lamine Paba.
Your choice, bring on behalf of the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Kaba, who's walking up. Judge, state your name, Mr. Kaba.
Amin Kaba.
Thank you.
Your Honor, we're asking for a brief adjournment. Mr. Kaba has cleared the first screening for the mental health report. He needs to be screened by CMH. I was in contact with them earlier this morning. They said that 2 weeks would be more than ample.
For
Yes.
next. Oh, gotcha. Okay. So I'll set the probable cause. I'll do April 23rd, 2026, 9 a.m. in case there's some hiccup. Just try to get it done. All right. Thank you.
Thank you. For the seat, I'll give you a notice.
Court calls case People versus Devon Thompson.
Your Honor, bring it for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Thompson, Your Honor.
Your name, sir?
Devon Thompson.
Thank you. What are we doing?
Your Honor, my office had a conflict. We did submit a motion to withdraw. We are in the process of trying to locate, or we're doing a new a motion withdraw. We're trying to find someone on the panel who is able to take this file.
Okay, but why we don't have that now?
We do not have that now. I just
Walks out of here without knowing who his attorney is.
that is
I get a PR.
yeah, that's correct, Judge. We did submit the paperwork.
Problem is he's here on a capital.
Yeah,
And
exactly,
I
Judge.
mean, I want to make sure he has an attorney. So let's do this. And I hate to hold the jail up. Let's take him back. See if we can get that accomplished
Thank
so
you.
that he can come back out and I'll let him know who his attorney is.
Thank you, Your Honor.
All right, for the passing. Court calls case People versus Preston Kelly.
Your Honor, Raymond Cook for the people.
How's that get?
Brian Rowley on behalf of Mr. Kelly. State your name for the record. It's
Preston Kelly.
Thank you.
Judge, we need some more discovery of this man. Well, Mr. Cook's looking into it. Hopefully we'll get it resolved. So if we could get a brief adjournment, please.
Probable cause April 23rd, 2026, 9 a.m.
Perfect. Thank you, Your Honor.
Court calls case People versus Awastan.
The people.
Probably I'm not pronouncing that first name correctly, but
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Khan.
her name?
A vase gone.
A waste?
A vase.
A base. I'll probably mess it up again. Right. All right. What are we doing?
Your Honor, we are requesting a preliminary examination for this matter.
Discovery is complete.
That's my understanding.
And would people have their witnesses available the 14th? Preliminary examination in person, April 14th, 2026, 9 a.m. That is before Judge Freshour. Found continue.
This is the reason. On top.
Okay, just a second. Court calls case of the People versus Cameron Larry.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Dante Lebo on behalf of Mr. Larry.
Name?
Cameron Larry.
Thank you. You're looking for an adjournment.
I am, Your Honor. We're requesting some media.
You may.
Your Honor, came to my attention, while the defendant was in custody, he made 3 calls to the victim from his PIN to her listed number. In those calls, he says things like, I'm in jail for 3 days, I've been here every day. what his bond is set at. He also states things like, we really can cut all that shit out. We can go our separate ways. Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rise to jail. Might not want to be, might not want to talk with me, but I don't believe that. Right, so you're about to keep me in jail for real. You're going to send me to jail for 10 years. Me writing you in your on your face. I was just childish. I apologize. Talking about the case, talking about you're keeping me in jail. Are you really going to press charges on me? And so at this point, I'm going to ask him if you're going to he violated his bond. He's called for it after he was arraigned and told not to have contact with her. And he didn't have contact with her. Talking about the case, talking about keeping him in jail and like that. So I had concerns and asked him to hear me that started to violate his bond.
Response, Mr. Allen.
Your Honor, Mr. Layers indicated to me that these calls would have been made prior to the arraignment. I understand.
It would have been made prior to his arraignment?
That is what Mr. Layers indicated to me. I haven't been able to verify that myself.
What's the date of the calls?
And calls are from 26. Along with one on 325 that was later in the evening. After he would have been arraigned.
I did discuss it with Mr. Lay. He does understand that.
Still want to keep representing to the court that they were made prior to his arraignment? What?
Oh, Your Honor.
Yeah, because that wasn't true. All right, go ahead, counsel.
Your Honor, all I can say is that Mr. Laird did indicate to me that he believed they were prior to his arraignment. I'm glad that he's.
Seriously? No, he didn't.
I'm glad.
Just saying that.
Yes, I'm glad.
Just got you to just say it.
Yes, and I'm glad that he's now come clean about that. He certainly understands that he cannot have contact.
She has to check any text. Wait a minute.
That's not helping.
Anything else?
I have nothing to add, Your Honor.
People's motion to modify bond. It's granted. Defendant's bond is hereby ordered the above. Defendant's remanded back to the Washington County Jail Court. They will also order that his phone privileges and texting privileges are hereby ordered the above. Defendant's remanded.
Thank you, Your Honor.
What's this?
16th. Court does call the case of the People versus Christopher Duffy.
Aliens and I would have to speak with her.
Michael Gaddy, assistant prosecutor on behalf of. Okay.
Okay. Mr. Duffy. Finding paperwork here. All right, this is on a new case. This is the case number on this is 26F20276.
And Your Honor, on that new complaint, I think this was charged back in October, so I think the patent code for the count 2 is in question 750.815.
For count 2. Oh, 815. Then I'll make that correction to the information of the start. Sir, you are before the court. This is an arraignment on this case. The alleges that on or about September 14, 2025, location of 118 South Grove Street in the city of Ypsilanti, that count 1 alleges that you did commit the offense of assault with intent to do great bodily harm less than murder or by strangulation. You understand the nature of that charge, sir? Yes, sir. That's a felony punishable by 10 years incarceration of $5,000 fine plus court costs. Count 2 is aggravated domestic violence, third offense. Do you understand that charge? That's a felony punishable by up to 5 years, $5,000 fine plus court costs. You understand that, sir?
Yes, sir.
Count 3 is the offense of child abuse, 4th degree. That is a misdemeanor punishable by up to 1 year or up to 5 years probation. You understand that charge, sir?
Yes, sir.
All right. Count 4 is the charge of malicious destruction of personal property, $200 or more, but less than 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Sir.
First question I have for you, and I'm sure you want to be represented by counsel, correct?
Yes, sir.
All right, this is public defender case.
Yes, I'm Michael Gaddy, Assistant Public Defender on behalf of Mr. Duffy, Your Honor. In terms of the arraignment, we'd stand mute.
Defendant having waived formal reading, standing mute. I will set his.
Your Honor, we have had a chance to discuss this matter with Mr. Duffy. He has another matter that's up for PCC today. If the people are in agreement to waive the PCC in this matter, we'd ask that both be set for exam.
All right.
And Your Honor, I do believe the discovery on the new file should be over to Mr. Gary in a relatively quick time frame. I also got a word back from my email I sent today, and I should have that body worn camera that we were missing on the other case to him by tomorrow.
Got it. Okay, that's right. That's what we're going to try to do on this. So what I will do on this case is that waive. I will further indicate that discovery is complete because you're getting it over there. And with the people who have their witnesses available the 14th, I will then set this matter, the new case for preliminary examination for 29 a.m. before Judge Moore.
Your Honor, if I could be heard on a bond.
Yes, go ahead.
Mr. Duffy has recently secured a new residence in Toledo, Ohio. He has a prohibition against leaving the state of Michigan. We'd ask that he be allowed to reside at the Toledo address. I do have it. I can give it to the court.
As to where he is.
Correct.
Okay. All right. On the new case, I'll set his bond at a $25,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. You're not to, I will order this and then I'll change it. So don't panic yet. I'm going to order that the defendant is not to leave the state of Michigan without permission of the court. I will also indicate the defendant is not to purchase, possess a firearm, ammunition, other dangerous weapon, or anything fashioned to be a weapon. You understand that, sir?
Yes, sir.
You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You understand that?
Yes, sir.
You are to have no contact with Ebony Thoreau whatsoever. Do you understand that, sir?
They allow me,
Except with a civil standby.
they allow me contact with her because she contacted them and asked, can I have contact? That's why I can go around her on GPS, tell her no.
I thought there was.
Go back to the magistrate when I got arraigned on the case.
You know what I mean? We approach.
Limited to phone, email, texting, internet, social media. You are also not to refer to that person online in any way. You understand that, sir?
Sir.
I will indicate also that he is not to go to the 118 South Grove Street, Ypsilanti Township, because you're not to go to that address except with a civil standby. My understanding now, that's not your home address, so I don't have to address that issue, but you can't go there. You're not to violate any criminal law or personally appear at all, you are personally to appear at all court proceedings or other places as to the court. You have a place that you're going to reside in Toledo, correct?
Yeah, see, we just had a baby, so I've been, working and helping her with the kids because, she been.
That's Miss Sorrell.
Yes.
Okay, I hear you. But where you're going to reside is in Toledo.
Yeah.
Okay. I'm going to add under the conditions, defendant may reside Toledo, Ohio. Okay. All right, that's on the new case. On the other case. All right, so on the new, I'm not going to order GPS on that case at this point. I'm going to leave the GPS on the other case, but I'm going to change. And so, so that, and Mr. Gaddy, you can put your objections on, but I want to explain the court's rationale. I don't want you to have two orders, one that you're looking like you're complying with and the other that you're not complying with, right, AJ? Because that just can be, it can end up being bad for you as you're trying to do the right thing or whatever, okay?
All right.
So on the prior case, that being 2243, I'm going to revoke the, or delete, yes, I should put, delete the no non-consensual contact. I'll let you get it. And I'm going to add the same conditions of no contact with Mr. Rell and no going to the 11 South Grove. Okay.
Yeah.
So that they match. Okay. Mr. Gaddy, what did you wish to?
Oh, just to put on the record, Your Honor, there was a no non-consensual contact order in the matter that was originally up today, the 25F2 2243 matter. Again, it's a 25 case. I don't think there's been any violations, alleged violation at order. There hasn't been the mutual contact or the approved contact by the complaining witnesses seems to have been going along fine. The matter that was arraigned today predates the alleged date of incident in that matter. So, as I asked at the bench, we would just ask, we would request that the no non-consensual contact stay in place, given the fact that that seems to be working.
Right, and I get it. It's just, had these come in the order that they were alleged to have occurred, there would have been, that wouldn't have ever happened. And I'm not sure why it did. Why it's
Contact with the prosecutor, explore that.
No, I
don't know why you weren't charged with the other.
I understand that.
Okay.
So what I got this, and it's confusing at this point. Okay, so I'm just trying to simplify it for you because you're the one, if something goes wrong, you're the one that's going to get locked up, right? So I'm just trying to simplify it at the same, and I'm not changing this condition so that the record's clear because the defendant has done anything. And I want that real clear. I'm not changing it. I'm just changing it for the reason of consistency. All right. And I'm also going to add to that case, because that case also says you can't leave the state of Michigan, that the defendant may reside in Toledo, Ohio. Okay, so I'm going to let him go to Ohio, do that, just try to maintain, and I know it's not what you want, but try to maintain it for 12 days, get to your exams on these cases, let's see what happens. Move from there. Okay,
Thank you, Judge.
best I can do.
Thank you.
All right, thank you, sir. Thank you for your patience, sir. All right. Court does call the case of the people versus Tricia Lopez.
All of the people. Brian Bowling on behalf of Ms. Lopez, Judge.
Tricia Lopez.
We have a resolution, Your Honor. There's a signed plea, or there should be a and advice of rights.
What if I told you it wasn't?
Then something happened, but
I got it. Don't worry about it. I just,
so, yeah.
I had this plea form indicates that she'll be pleading guilty to the charge of disturbing the peace. But the 90-day offense upon her successful plea to that charge count on. That's the court's full understanding.
Defense's understanding of the agreement as well, Judge.
And have her sworn.
Do you solemnly swear to affirm the testimony with the truth, the whole truth, and nothing but the truth?
Yes. Trisha Lopez?
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in 14B District.
Yes.
Do you wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have trial of any kind.
Yes.
Signed in advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you are indeed guilty of this offense? On the date of December 30th, 2025 at 3375 East Michigan Avenue, lot 270, Ypsilanti Township, Washington County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I got in an argument and it was really late and I got loud and I disturbed the peace because people can hear me outside my trailer.
All right. Oh, I think she got everything. Ma'am, if between the time that I accept your plea and between the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I'm aware of none.
And have I complied with the court rule? Would it be proper to accept this?
What's that as well?
As am I. Thanks, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 7, 2026, 10 a.m. for Judge Washington. Bonds will continue.
Let me know. Let me know if you need.
You're welcome.
Thanks, Judge.
Court. The next door refusing. Court does call the case People versus Deion Baldwin. That's yours, Mr. Client's not. He's refusing to come out.
Okay, well, this kind of works out. I was gonna have for the German anyways, because we weren't able to see him.
Yeah. Probable cause conference will then be adjourned to April 30th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Jasmine Morris.
Thank you for calling Language Lines.
Jasmine Morris, who's on this? Just come on up here. Come on. Mr. Gaddy's in the courtroom. State your name.
Veronica Joy on behalf of Ms. Morris, thank you. I am not sure what Stephanie wanted to do in this case.
Well, your client's refusing to come up.
To 7411 in this matter.
That is.
Okay, no other promises than that, Judge.
Likewise, promises.
And have I complied with the court?
That's what.
Defense is satisfied, Judge.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered at 14A3 probation. Sentencing in this matter will be
May 18th at 9 a.m.
May 18, 2026, 9 a.m. before Judge Freshour. Bond continue.
Thank you. I'll email you the
Thank you.
I'll email you the contact information for probation, sir.
Court calls the case People versus Laura Smith.
People.
Should be hearing rise.
Via Zoom. Ms. Smith, can you unmute and say your name? Said she's trying. I read lips. Okay, state your name.
Laura Smith.
Thank you. What are we doing?
Your Honor, we have come very close to a resolution in this matter in terms of a misdemeanor resolution with an attempted resisting and obstructing and an OWI second. We are asking for an adjournment just to work out some details. And I apologize, I did not do a green sheet.
Your Honor, may we approach?
Sure. Record should reflect we had a bench conference in this case. I will adjourn this matter to April 23rd, 2026. 9 a.m. or as your invite indicates, bond will continue. All right. Thank you, Ms. Smith.
Thank you.
Court calls case People versus Matthew Smith.
People.
Assistant Public Defender Dr. Lebo for Mr. Smith, who appears via Zoom.
Hello.
Hello. Your name, sir? All right. I got enough of that. Okay. What are we doing?
No.
I'm going to say it's just currently at Bear Grip. A potential, honestly, potential knowledge. We don't know how much longer.
Okay. Mr. Smith, when do you finish the program at Bear River, do you think?
I'm not, I'm still in the outpatient after this one, so I'm not sure.
You're not sure? Okay.
Yeah, I'm
Let me put it out 30 days. Let's see where he is at that point. All right, I'm going to adjourn your probable cause conference to May 7th, 2026, 9 a.m. or as your invite indicates, bond continued.
Is it, excuse me, Your Honor.
Yes, sir.
I was wondering if it was possible, my lawyer somehow, or should I call him?
Yeah, you'll have to call him or he'll call you.
Okay, thank you.
All right. Thank you.
Said May 7th?
Yes, sir.
Okay.
All right. Thank you. Court call States People versus Sarah Ward.
For this matter, on behalf of people, Michael Gaddy, Assistant Public President of the F1, this report of the issue.
Your name?
Sarah Ward.
Yes, ma'am.
Yes, Your Honor. I think we're resolved here. We just need a brief adjournment to get the plea paperwork again.
Probable cause conference April 16, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. For cause case versus Marius Warren.
Can I move it for your honor?
Brian Glenn on behalf of Mr. Warren.
Check.
State your name for the record.
Maurice Warren, sorry.
Your Honor, we would like to request an adjournment.
During the matter to April 23rd, 2026, 9 a.m. All right, thank you.
Thank you, Your Honor.
Court calls the case, People versus Angelise Warren.
Roy Gaines, the Assistant Public Defender representing Ms. Warren. Your Honor, we received the report from Community Corrections that indicated that Ms. Warren is currently in the Wayne County Jail. By the time Ms. Mackey reached out to the court, it was, because we just received it this week, it was too much for her to be here. We're asking for an adjournment.
Well, adjourned, see if we can do a video read. April 23rd, 2026, 9 a.m. Bound continue.
Thank you.
Court calls. Honorable Cause Conference, April 6th.
As the bond judge, I'm asked for a PR bond with GPS tether. I'm working on a plea right now, which will require restitution. She could get her job back if she is released from jail. She's been sitting for 12 days on the violation, on the bond, I should say, she couldn't afford.
Hang on. Can you? Thank you. As, do I have a response from the people?
I have no objection to the GPS. I believe the reason for the bond being set the way it was because the defendant does have prior failures to appear on other cases. So there was a flight concern, but I feel that with a GPS tracking tether that way.
How many prior failures to appear?
I believe that she actually has 2 misdemeanors in front of your honor. One township, one state case that she was here at over a year ago. I don't know if those are set for another trial or pre-trial date or arraignment date yet. I believe there's CCH also indicates that there was a failure to appear on, I want to say it was 33rd district, but I can double check that. But there's 3 failures to, well, a failure to appear on 3 different cases.
And Judge, I could briefly reply to that.
Go ahead.
The 33rd district, it looks like that case is not in play anymore. I did call them up. I do know there's been some issues, but I also know she's been sitting for 12 days. I just got this file. I intend to get everything wrapped up into one. She does need to pay the restitution. I also did a bond memo.
A drug issue involved in this?
Not that I'm aware of, Your Honor.
Or a substance abuse issue? Because the magistrate set the bond at the 10,000, 10%. And indicated consider release to treatment. Does anybody have anything of a substance abuse history with this defendant?
Nothing in the court system. Yeah, Judge, to my knowledge, there's nothing in the court system about drug use.
What?
Nothing in the system about drug use in the court system. I don't know what she's done in her personal life before I got involved, but I have no notes on that.
Well, somebody needs to check into that. There's a reason why the magistrate indicated that. I would sign an order for her release to treatment on a PR with a GPS tether, which is what's set. That may be appropriate in this case. Certainly I'll address it again on the 60. But at this point, that's all I'm going to do. So our bond will continue. I'll sign an order for release to treatment on a PR with a tether.
Glad to see you.
Okay.
Be in front.
Yeah.
Court calls case People versus Jennifer Baker.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who should be in appearance via Zoom, Your Honor.
Good morning.
Good morning. Your name?
Jennifer Baker.
All right. Thank you.
Your Honor, we are just on this matter. I have been in talks with Mr. Hawthorne with regard to an offer. He advised that he just needs to check in with the appropriate individuals.
That's correct, Joe.
Probable cause conference will be adjourned to April 23rd, 2026, 9 a.m. Bond continued.
Your Honor.
Thank
Court does
you.
call. Thank you, ma'am. Court calls case People versus Troy Swope. Goldstein.
David I. Goldstein appearing on behalf of the defendant.
Troy Swope. All right, what are we doing?
Your Honor, in this matter, I had spoken to Mr. Chavalowski about a resolution that I was planning on discussing with my client this morning. But as I think the court is aware, there was something intervened which prevented me from being here this morning. So I'm asking for a 1-week adjournment, but we did also address bond last week. And you indicated you wanted to see some proof or some information regarding the Suboxone regimen that he is on. I attempted to provide that to the court this morning by Zoom. Your clerk indicated, however, that it may not be readable, and if so, I can read it to the court.
It's hard to.
Yeah, my copy is a little better, Your Honor. I might be able to read it to the court. Basically, it came from Trinity Health, the group recovery medicine. They confirmed that he is on Suboxone, and they are monitoring him. There was a period of time when he was, because of his insurance problem, that they were unable to provide it, and that was when he relapsed. But he is back on the Suboxone, and they are monitoring him. And that's coming from Francis Michael James at the Trinity Health IHA Medical Group Recovery Medicine.
Okay, I don't know why Bellinger has it, but I got a good copy. He's just because Bellinger's in everybody's business. I actually have a very good copy that I can read. And it's funny, Mr. Goldstein, while he watched us old people struggle to read it, Bellinger got the good copy right here.
You're welcome, Mr. Goldstein.
Johnny on the spot, or say Jay on the spot is what I should say.
Right. But this is not indicating that he's back in treatment, right?
One moment, Your Honor. I've got to address something real quick. I'll be right back.
Yeah, I don't.
You need some music?
Yeah.
Back, Your Honor.
You're the only one that would ever be able to get away with that. All right. This does not indicate that he's in treatment, however. It indicates that there was, but if I'm reading it correct.
Okay. Is the one you have dated April the 1st, Your Honor?
It is.
Okay. I mean, it does say
what it's telling me is that he reestablished connection to the clinic on February 25th. However, they're unable to comment on his compliance, given that he failed to follow up with the urine screen ordered on that day.
Your Honor,
So
there's another document. I'm sorry, Judge. There's another document that I have that indicates that he did appear but didn't have the money. That's why it was not completed.
Is that,
This is also for Mr. Bellinger.
Mr. Bellinger has that one too?
Yeah.
Okay,
don't know
hold
if
on.
Mr. Goldstein has.
No, Mr. Goldstein is reading from his phone. I don't know why Bellinger has any.
Your Honor, his family's here and has.
Oh, and they're handing you stuff? Why didn't you tell me that?
Your Honor, I didn't.
You just were making it look like you were doing something. Hold on one moment, man. All right. Yes, ma'am. What's your name?
States that we didn't have the $400 for the drug testing that day, but if you look, we did reschedule it.
When is it rescheduled?
I don't remember the exact date. I went to the clinic today and they highlighted it to show like we didn't have the $400 for it and we needed to do that.
Okay, so I get it. So there was an insurance issue. You had to pay it out of pocket, which was 400. You didn't have the 400. It's not like you didn't have $25 for testing.
Exactly.
You didn't have $400 to follow through because of insurance. All right. Thank you, ma'am. What is your name? Because I have to have it on the record. Your name's Emily? Will that work for you? Okay. And your relation to, really? You're smiling about it. Oh, okay, never mind. What? Look at who? That's mom? Who's mom? That's Mr. Swo's mom? Okay. You like her? You do? Okay. I was just being nosy. It has nothing to do with my decision. So, what was his previous? Mr. Goldstein, what was his previous bond set?
Yeah,
I think
I'm
he
at
was on
home. I don't have the file with me.
5,000 PR.
Yeah.
And then to comply with treatment. So what I will do, I'll grant well, we got to set this out. You want this set to what date, sir?
Next week, Your Honor. Next Thursday.
I'll set it to April 9th, 2026, 9 a.m. I'll reinstate the defendant's previous bond of personal recognizance, $5,000. Follow all treatment and everything. You understand that, young man?
Sure.
Yeah. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Manuel Barnhouse.
Here, Your Honor.
Ms. Tanner?
No, here she comes.
Good morning.
And she was late today.
Gosh.
No, she was. She was
It was
just late.
rain,
She
traffic.
said it's because it was raining and that she melts. But that's what I heard from the whole conversation. But go ahead. I'm sorry.
Morning, Your Honor. Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Stephanie Cannon.
Permission to practice is granted.
Thank you.
All right. And Mr. Barnhouse has.
Right here,
All
Your
right.
And we're requesting adjournment.
You're requesting an adjournment.
Yeah.
And you approach? Yes. All right, record should reflect we've had a bench conference in this case. Probable cause conference will be adjourned then to April 16th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls case, People versus Deion Baldwin.
Michael Gaddy, Assistant Public Defender on behalf of.
Baldwin, can you get somebody to unmute you and state your name? All right, stay right there, Mr. Baldwin. I'm going to pass it. I'm going to try to call another matter and then right to you, okay? Well, no. Okay, good. Court calls the case. People versus Jerome Adams.
Michael Gaddy, Assistant Public Defender.
And for the record. Oh, Jerome Adams. Yeah, may we approach briefly?
Yes. Well, if we verify that, then I'll the court calls the case, People versus Glenn Bradford.
Alice said on behalf of.
Assistant Public Defender Jay Ballinger on behalf of Mr. Bradford, who approaches.
Bradford.
Well,
And Your Honor, we are seeking an adjournment on this matter for purposes of negotiations, and I would also be asking to address Vaughn. I do understand that he is out of custody.
so this could go south. Okay, no, that's fine.
Always
fine. I will adjourn it to April 23rd, 2026, 9 a.m. As to bond.
As to bond, Your Honor, my understanding is that this case was initially charged last September, then dismissed, and then at the beginning of March, and then recharged at the end of March. During that intermittent time period, Mr. Bradford and his wife began marriage counseling. My understanding is that she's here today and she has had an opportunity to speak with the victim advocate. My client, Your Honor, would be asking for his GPS tether to be removed as well as for contact to be reinstated. Reasons being, Your Honor, they are doing that marriage counseling. They'd like to continue to do so. And again, my understanding is that she's okay with the no contact being lifted, but I would inquire as to what Ms. Zinda thinks.
Really? You're going to ask?
I don't necessarily want to know the answer, Your Honor.
I rolled to say, is there a risk? That's okay, Bellinger. You keep wanting to go ahead. There's going to be a line today. He's going to cross it. You're really stamping on it. Ms. Zinda.
Spoke with her. She requested no contact to be removed. She said she was not afraid of Mr. Bradford. And I do understand that they are in marriage counseling, so I will leave it in the discretion.
I will add a provision of no non-consensual contact. I will delete the no contact as well as the no go to provision. and defendant's GPS tether may be removed.
Thank you very much, Your Honor.
Thank you, Your Honor. You're welcome, sir. I did it for you, not yours. Wait.
Okay, so go over to
Wait, Bellinger. You never know a bond. I'll pay. Remember that case, Bellinger. Hear me, Bellinger?
I'm so sorry, Your Honor.
When you're up there screaming and yelling about, you never change your bond. You never, for us, never do anything.
When do I remember that?
Remember, do that all the time.
Thank you, Your Honor.
That out there. Court calls the case, People versus Wardell Smith.
And is that
Morning, I'm Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
And Your Honor, here's your response.
All right, preliminary examination will be set for, will the people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge,
Yeah.
may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
Because I know what she's gonna say, so I want to beat her to the punch.
Okay, go ahead.
Judge, no, not to be facetious, but my understanding he's got a $50,000 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000 10% bond tether if necessary. He's the sole supporter of the family. He will stay away from the marital home as for now and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made as a meeting by the last check was 65 calls to the victim's listed number, which we have had contact on before from his pin since being arraigned in the jail. I and for his phone privileges and text privileges to your votes in those calls. There terms of human, I love you, babe, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction of bond on tether.
I'm going to deny the request. He's violating the conditions of his bond, or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue defendant's phone privileges and texting privileges to her. Hereby ordered for vote pending a hearing. Thank you.
Yeah, I'll come and see you. Thank you, Your Honor.
Court calls the case, People versus LaShawn Charles.
Oh, no, good people.
Really? LaShawn Charles?
Good morning,
Good morning. State your name.
LaShawn Charles.
Thank you. We're waiting on your attorney Bellinger.
Okay.
I'm not going to hear Miss Gaines. Where's Bellinger? Where is he? Where? Gee, oh, Pete, I called this case like hours ago. Oh, I called the case a long time ago and we've been waiting on you.
So sorry.
No, you're not.
I am.
No.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Charles. Hi, Ms. Charles.
Hello.
It's already stated her name about 55 minutes ago.
Your Honor, this case is currently with Victoria Burton Harris. I have emailed her with regard to a resolution. I'm just waiting on her to get back from her leave. She is back on the 6th, I'm told. So I would just ask for an adjournment past that date. We should have an answer at that point.
Have an answer by then. All right. Probable cause conference will be adjourned to April 16th, 2026, 9 a.m.
Thank you very much.
Bond will continue. Thank you, Ms. Charles, and thank you for your patience in waiting for.
Thank you so much.
Court calls the case, People versus Tyler Watts.
The Assistant Public Defender Natalie Pate on behalf of Mr. Watts in the case 25FB1347. And Sherilyn Foster Tucker on behalf of Mr. Watts in the case ending in 1734.
All right. What are we doing? Because I have a plea form in your case.
That is correct, Your Honor. And Your Honor, in my case, I just jumped into this case yesterday, so we were not able to get the paperwork in. I'm just asking for a brief adjournment so we can finalize a plea agreement.
On this case?
It makes sense. I don't.
Go ahead.
If we PD case today, or we can adjourn both, they could be on both. Sure.
Is he being held on anything else or?
Yes, Your Honor, he's being held on a violation of probation in circuit court, but Mr. Watts indicated to me he believes he has a release to treatment on it. Oh,
That, I'm sorry.
but he believes he has a release to treatment on that file.
Okay. I normally wouldn't do this, but I don't know. Ms. Westertucker, are you, that's a guilty to a misdemeanor of some type? That what it is?
Yes.
And does he wish to do that? Or, okay, if we can. Okay, I normally wouldn't do this, but if we can get the paperwork in, let's try to take care of it today, get it done. Unless somebody has an objection to that.
Oh, that's fine.
All right.
No problem with that.
All right, so I'll pass these matters. We'll take you back and we'll get you out here to try to get it done. All right, young man? All right, thank you. Oh, another young man. Joe Simon. Huh? Yeah. Oh, good morning, sir. It's a pleasure seeing you.
As well.
Hawthorne said he didn't want to talk to you. He told me that early today.
Well, I can tell you that he never responded to my reach out yesterday.
That's what I'm telling you. So why'd you bum rush him like that? All right.
Just wanted to say.
Okay. All right. I don't want to get into that between you two. I'm done. Court calls the case. People versus Danina Combs.
I'm calling on behalf of Ms. Combs, who hopefully should be on Zoom.
Morning, Mr. Bull. Oh, well.
Awesome.
Yeah, I'm here.
Oh, hold it.
All right.
Hold it. It's a phone call.
Yeah.
Your name?
Danina Combs.
Thank you. Phoned in. That's why.
Yeah, great. I'm glad she's here. Your Honor, I spoke to Ms. Combs yesterday. I also had some discussions with Mr. Childred. We're looking at possible resolution options of this matter or these matters, if you will, and need a little more time.
A little more time. 23rd work for you?
Sure.
All right. Probable cause conference will be adjourned April 23rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case People versus Bryant.
Brian Bowling on behalf of Mr. Bryant.
Simon, put that back. John. Your name, sir?
My name is Jason Bryan. How you doing, sir? Sorry to see you this again.
Oh, why?
Just in this context.
Oh, in this way.
Yes, yes. I'm just.
How are you doing?
Not so pleasant.
All right. Let's see what we can do to try to get you through this.
Your Honor, I met with Mr. Bryan at the jail yesterday. We're just asking for an adjournment for some additional plea discussions.
All right. Why don't I just put it up 2 weeks, put it up to the 16th, April 16th, 2026, 9 a.m. Bond continue.
Perfect. Thank you.
All right. Thank you.
I don't know if I'll be doing something.
He's in Zoom?
Yeah.
Okay. Court does call the case. People versus Orby Huffman. Your name, sir?
Orby Byron Huffman.
All right. And Mr. Huffman, you're intending upon representing yourself?
Yeah,
I'm sorry, you said what?
yes,
All right. I do have to again apprise you that you are before the court on the charge of assault of a prison employee. You understand that charge?
yes, I do.
That is a felony punishable by up to 5 years incarceration, a $2,500 fine plus court costs. You understand that, sir?
Yeah, I hear you.
You understand that there are difficulties when you are representing yourself, but I need you to be apprised that the court will treat you the same, as you won't receive any worse treatment, you won't receive any better treatment. You understand that?
Yes, I do.
And you also understand that the court will presume that you have knowledge of court procedure and court rules. You understand that? The court will not be in a position to assist you regarding any of that. You understand that, sir?
Yes, I do.
Do you still intend upon representing yourself?
Yes, I do.
I do have to also tell you that if at any time you change your mind and you wish to be represented by counsel, you just need to inform the court, and the court will ensure that counsel is appointed to represent you. You understand that?
Yes, I do.
All right. What are we doing on this case?
I would indicate, I've just been informed by several of my colleagues that Mr. Orby was before Judge Conlon yesterday on a case where he's represented by David Burgess, referred for a competency evaluation.
Oh, he was referred for a competency in that case? Oh. Given that, would the people be requesting that I refer for competency on this case?
Because at this point, there's a question with respect to his competency, and we need to know that he is in fact competent before we vote.
Mr. Huffman, anything you want to say regarding that?
I cannot hear what he said.
What he indicated is that you were before Judge Conlon, that you were referred for competency on that case. And that then a hearing was set. I then asked whether or not the people would also be requesting, given that information, that you be referred for competency on this case to make sure that we can proceed forward. The people have made that request. I then asked whether or not you had a response to that.
I feel like I'm capable of representing myself.
All right, thank you. Given the information that has been provided regarding a competency evaluation, the court will order on people's request a competency hearing, a forensic evaluation. I'll set a competency hearing for
July 2nd.
July 2nd, 2026, 9 a.m. And Mr. Childers, I will need an order. All right. Bond will continue. Thank you, Mr. Huffman.
What is bond?
I'm sorry?
What is my bond?
Your bond in this case, as set, is $50,000 cash surety.
Is that 10%?
No, it is cash surety.
Thank you.
Thank you. Court does call the case, People versus Daniel Haynes.
Assistant Public Defender Davi Lebo for Mr. Haynes. Haynes, can you tell the judge your name, please?
Daniel Haynes.
Thank you.
And Your Honor, we'd like to set this matter for preliminary examination, please, and discovery is complete.
All discovery is complete.
It is, Your Honor.
People have their witnesses available the 14th. Preliminary examination in both of these matters will be set for April 14th, 2026, 9 a.m. before Judge
Judge Freshour.
Freshour.
Thank you, and I just want to briefly address bond.
Go ahead.
Mr. Haynes indicated to me that he was not able to appear previously due to a lack of.
What happens when a defendant confidently tells a judge, I can represent myself, but the courtroom suddenly comes to a complete stop? This wasn't a heated shouting match or an emotional outburst. Instead, it became a tense legal moment where one decision changed the direction of the entire case. And by the end, the judge made it clear that the case couldn't move forward until one critical question was answered. Welcome back. Today's courtroom moment is a reminder that confidence alone isn't enough inside a courtroom. Every defendant has important constitutional rights, including the right to represent themselves. But before allowing that, a judge must make sure the defendant is legally competent to understand the proceedings. That's exactly where this hearing takes an unexpected turn. The judge begins by carefully explaining the seriousness of the charge. The defendant confirms that he understands the felony accusation, the possible prison sentence, and the risks of acting as his own attorney. The judge goes even further, warning that the court will expect him to follow the same rules and procedures as any licensed lawyer. No special treatment, no extra help. The defendant says he understands every warning and still chooses to represent himself. But then the prosecutor raises a major issue. The court learns that in another pending case, the same defendant had already been referred for a competency evaluation. That immediately changes everything. Instead of rushing forward, the judge pauses the case and asks whether the prosecution wants a competency evaluation in this case as well. The defendant responds calmly, saying he believes he is fully capable of representing himself. Even so, the judge explains that the court must first resolve the competency question before allowing the case to continue. The judge orders a forensic competency evaluation and schedules a future competency hearing. The defendant's bond remains unchanged while the evaluation process moves forward. Rather than debating guilt or innocence, the hearing becomes focused on making sure the legal process is fair before any further proceedings take place. Moments like this show that courtroom decisions aren't always about dramatic arguments. Sometimes the biggest ruling is simply deciding whether the case is legally ready to proceed. Do you think the judge made the right call by ordering a competency